Part 2, General Provisions for Care and Protection of Children. 25. In this part, employment means employment in any undertaking, trade, or occupation, carried on for profit or gain, irrespective of whether the employment is gratuitous or for reward. Industrial undertaking includes a mine, quarry, distillery or brewery, or a sugar, spirit compounds, match, soap, cigar or cigarette factory, or any undertaking in which articles are manufactured, altered, cleaned, repaired, ornamented, finished, adapted for sale, broken up or demolished, or in which materials are transformed, including shipbuilding and the generation, transformation and transmission of electricity and motive power of any kind. B. Construction, reconstruction, maintenance, repair, alteration or demolition of any building, railway, tramway, harbour, dock, pier, canal, inland waterway, road, tunnel, bridge, viaduct, sewer, drain, well, telegraphic or telephonic installation, electrical undertaking, gas work, water work, or other work of construction, as well as the preparation for or laying the foundation of any such work or structures. C. Transport of passengers or goods by road, air, rail, or inland waterway, including the handling of goods at docks, wharves, airports, and warehouses. Night work means work between the hours of 10 o'clock in the evening and 5 o'clock in the morning. Ship means any seagoing ship or boat of any description. 26. The person to whose care a child is committed or transferred by an order made under this Act shall, while the order is in force, have the same rights and powers and be subject to the same liabilities in respect of the child's maintenance as if he were the child's parent, and the child so committed or transferred shall continue in his care notwithstanding any claim by a parent or other person. 27. 1. It shall be the duty of every person responsible for the maintenance of a child to provide the child with adequate food, clothing, lodging, and health care appropriate to the age and needs of the child. 2. Any person mentioned in subsection I, who is financially unable to provide for a child in accordance with subsection I, shall apply to the minister in the prescribed manner, for assistance. 28. 1. Every person having the custody, charge or care of a child between the ages of 4 and 16 years shall take such steps as are necessary to ensure that the child is enrolled at, and attends, school. 2. Where a person having the custody, charge or care of a child is financially unable to provide the child with any article required for the purposes of the child's education at a school at which the child is registered, that person shall apply to the minister, in the prescribed manner, for assistance. 3. The minister may by order published in the Gazette amend subsection 1, by increasing or decreasing any age specified in that subsection. 29. 1. Where a court makes a fit person order or an order sending the child to a juvenile correctional center, the court may order the following persons to make contributions in respect of the child. A. The child's father, adopted father or stepfather. B. The child's mother, adopted mother or stepmother, and C. Any person who, at the date when any such order is made, is cohabiting with the mother of the child, whether he is the putative father or not. 2. Where a child has been committed to the care of a fit person, contributions under this Act shall be payable to the government agency responsible for children, to be applied in or towards the maintenance, or otherwise for the benefit, of the child. 3. Where a child has been committed to a juvenile correctional center, contributions under this Act shall be payable to the Commissioner of Inland Revenue. 31. A contribution order may be made in accordance with this section where a fit person order or a correctional order has been made in respect of a child. 2. The contribution order may be made, a. by the court which makes the fit person order or the correctional order, at the same time when it makes that order, or, b. subject to the provisions of section 32, by any court of summary jurisdiction. Having jurisdiction in the place where the person to be charged is for the time being residing, on the application of I. the person to whose care the child is committed, or 2. the minister in the case of a committal to a juvenile correctional center. 3. The contribution order shall require any person who is liable to make contributions under section 29, in respect of any child, to contribute such sum as the court thinks fit having regard to his means. 4. A contribution order a. shall, unless varied or revoked, remain in force so long as the child remains in the care of the fit person or juvenile correctional center. And the court when making such order shall have regard to any affiliation order in force in respect of the child. b. May be varied or revoked on the application of either the contributor or the government agency responsible for children. 5. A contribution order shall be enforceable a. where a child has been committed to the care of a fit person, at the instance of the government agency responsible for children, or b. where a child has been committed to a juvenile correctional center, at the instance of the minister in the same manner as an affiliation order made under the Affiliation Act. 6. A person against whom a contribution order is made shall, if he changes his address, forthwith give notice thereof to the government agency responsible for children, and any person who fails to comply with the provisions of this subsection, or who knowingly gives notice that is false in any material particular, commits an offense against this Act. 31. 1. Subsection 2, or 3, shall apply where a court makes a fit person order or a correctional order, and an order for the child's maintenance is in force. 2. The court which makes the order referred to in subsection 1, may, at the same time, order the payments under the maintenance order to be paid to the person to whom contributions in respect of the child are payable under section 29. 3. Subject to the provisions of section 32, the powers of the court under subsection 2 may be exercised by any court of summary jurisdiction having jurisdiction in the place where the putative father is for the time being residing, on the application of the person who would be entitled to apply for a contribution order. 4. Any sums received under the maintenance order shall be applied in like manner as if they were contributions received under a contribution order. 5. If the putative father changes his address, he shall forthwith give notice thereof to the government agency responsible for children. And, if he fails so to do, or if he knowingly gives a notice that is false in any materia, one particular, he commits an offense against this Act. 6. The making of an order under this section with respect to a maintenance order shall not extend the duration of that order. 32. 1. Any reference in section 32, b, or 31(3) to a court having jurisdiction in any place of residence for the time being shall a. in relation to a place in the parish of Kingston or the parish of St. Andrew, be construed as a reference to the family court corporate area region, and b. in relation to a place aforesaid in a parish within the geographical jurisdiction of a family court established pursuant to Part 2 of the Judicature, Family Court, Act be construed as a reference to that family court. 33. No person shall employ a child under the age of 13 years in the performance of any work. 34. 1. No person shall employ a child who has attained the age of 13 years, but who has not attained the age of 15 years, in the performance of any work other than in an occupation included on the list of prescribed occupations referred to in subsection 2. 2. For the purposes of subsection 1, the minister shall maintain a list of prescribed occupations. A. Consisting of such light work as the minister responsible for labor considers appropriate for the employment of any child of the age referred to in that subsection, and b. Specifying the number of hours during which and the conditions under which such child may be so employed. 3. No person shall employ a child a. in the performance of any work that is likely to be hazardous or to interfere with the child's education or to be harmful to the child's health or physical, mental, spiritual or social development, or b. in night work or an industrial undertaking. 35. I. Notwithstanding the provisions of sections 33 and 34, the minister responsible for labor may, on the advice of the Council, issue a permit to a child to enable that child to be employed for the purpose of participating in artistic performances. 2. A permit issued pursuant to subsection 1 shall specify the number of hours during which and the conditions under which the child may be so employed. 36. Where any child is employed in contravention of any of the provisions of section 33 or 34, any person to whose act, default or representations the contravention is attributable commits an offense against this act and is liable upon summary conviction before a resident magistrate to a fine not exceeding $500,000 or to imprisonment for a term not exceeding 6 months or to both such fine and imprisonment. 37. If it is made to appear to a justice of the peace that there is reasonable cause to believe that any of the provisions of section 33, 34, 39 or 40 are being contravened with respect to any person, the justice of the peace may by warrant authorize any constable to enter any place in, or in connection with, which such person is, or is believed to be, employed, and to make all necessary inquiries therein. 38. Nothing in section 33 or 34 shall be construed to apply to the performance of work by any child a. under order of detention in a juvenile correctional center or a community service order, or b. as part of that child's instruction in any school, if such labor or work is not likely to be hazardous or to interfere with the child's education, or to be harmful to the child's health or physical, mental, spiritual or social development. 39. 1. A person commits an offense if that person a. employs any child in a nightclub, or b. in any manner, uses a child for the purposes of any conduct contrary to decency or morality. 2. An owner or operator of a nightclub who permits a child to enter into, or remain in, the nightclub commits an offense. Provided that no person shall be guilty of an offense under this section if he proves to the satisfaction of the count that at the time of entry and while the child was permitted to remain on the premises, the person took all reasonable steps to ascertain and reasonably believed that the person was not a child. 3. An owner or operator of a nightclub or premises, who commits an offense under subsection 1 or 2, shall, in addition to any other penalty to which he may be liable under this act, be liable to have his license to operate the nightclub revoked and in the case of such revocation, shall not be eligible to be issued a license to operate a nightclub until the expiration of the period of 3 years from the date on which such owner or operator is convicted for the offense. 4. Any person who knowingly rents, or allows his premises to be used, for the purposes of any conduct mentioned in subsection 1, involving a child, commits an offense. 5. A person who commits an offense under this section shall be liable upon summary conviction before a resident magistrate to a fine not exceeding $1 million or to imprisonment for a term not exceeding 1 year. 41. An owner or operator of an establishment that sells or serves intoxicating liquor or tobacco products shall ensure that A. No intoxicating liquor or tobacco product is sold or served by the establishment to any child, and B. No child is employed by the establishment to sell or assist in the selling of intoxicating liquor or tobacco products. 2. A person commits an offense if that person A. Contravenes subsection I. B. Employs a child to sell or assist in selling intoxicating liquor or tobacco products, or C. Purchases intoxicating liquor or tobacco products from a child. Provided that no person shall be guilty of an offense under this section if he proves to the satisfaction of the court that at the time of the sale or purchase in the case of paragraph C, he took all reasonable steps to ascertain, and reasonably believed, that the person employed, or the person to or by whom the intoxicating liquor or tobacco product was sold or served, as the case may require, was not a child. 3. In this section, tobacco products means cigarettes, cigars, cheroots or cigarillos. 41. 1. Every person who A. Causes or procures any child, or B. Having the custody, charge or care of a child, allows the child to be in any street, premises or place for the purpose of begging or receiving alms, or of inducing the giving of alms commits an offense against this act. 2. If any person while singing, playing, performing or offering anything for sale in a street or public place has with him a child who has been lent or hired out to him, the child shall, for the purposes of this section, be deemed to be in that street or place for the purpose of inducing the giving of alms. 3. Where an offense under this section is committed by a person mentioned in subsection 1, b. A. In the parish of Kingston or the parish of Street, Andrew, such offence shall be triable by the Family Court Corporate Area Region, and B. In a parish within the geographical jurisdiction of a family court established pursuant to Part 2 of the Judicature, Family Court, Act, such offence shall be triable by that family court. 42. 1. No child, other than an infant in arms, shall be permitted to be present in court during the trial of any other person charged with any offence, or during any proceedings preliminary thereto, except during such time as the child's presence is required as a witness or otherwise for the purpose of justice or in such other circumstances as the court may determine. 2. The court shall order the removal of any child who is present in court in contravention of this section. 43. 1. Where, in any proceedings in relation to an offence against, or any conduct contrary to, decency or morality, it appears to the court that a person who is called as a witness is a child, the court may direct that all or any persons, not being members or officers of the court, parties to the case, their attorneys at law, or persons otherwise directly concerned in the case, be excluded from the court during the taking of the evidence of that witness. 2. The powers conferred on a court by this section shall be in addition and without prejudice to any other powers of the court to hear proceedings in camera. 44. 1. In relation to any proceedings in any court which arise out of any offence against, or any conduct contrary to, decency or morality, the court may direct that A. No report of the proceedings shall reveal the name, address, or school, or include any particulars calculated to lead to the identification of any child concerned in the proceedings, either as being the person against or in respect of whom the proceedings are taken, or as being a witness therein. B. No picture of any child so concerned in the proceedings as aforesaid, shall be published, except in so far, if at all, as may be permitted by the direction of the court. 2. Any person who publishes any matter in contravention of any directions given under subsection 1, commits an offence and is liable upon Summary conviction before a resident magistrate to a fine not exceeding $1 million or in default of payment to imprisonment for a term not exceeding 12 months. 45. 1. No report of any proceedings in a children's court shall reveal the name, address or school or include any particulars calculated to lead to the identification of any child concerned in those proceedings, either as being the person against or in respect of whom proceedings are taken or as being a witness therein, nor shall any picture be published as being or including a picture of any child so concerned in any such proceedings, provided that the court may in any case, if satisfied that it is in the interests of justice so to do, by order dispense with the provisions of this section to the extent specified in the order. 2. Any person who publishes any matter in contravention of this section commits an offense against this Act.